Oh, I have to push the button, don't I? Defendants in criminal trials ordinarily have a jury trial, but if the opposing party consents, they can choose to have a verdict decided by the judge, and this is known as a bench trial. So there you go. You can either have a bench trial or you can have a jury trial. Now the question is it better to have a bench trial or a jury trial? So they looked into this back in 1966. 1966, the year before I graduated from high school. That was 53 years ago. Calvin and Zeisel looked at district court judges, and they asked them all these questions, trying to determine would it be better for did the judges agree with the jurors in most cases. And what they discovered was about 75% of the time the jury and the judge would come up with the same conclusion. But of course, this is 53 years ago. In only 19.5% of the criminal cases did the jury return a guilty verdict where the judge would have ruled not guilty, or vice versa, only about 20% of the time. Approximately 5% of cases resulted in a hung jury. Of course, you can't have a hung judge. It doesn't happen. He always makes a decision. In most of the discrepant decisions, the jury was more lenient than the judge was, and this can be a problem.
So if the judge makes a decision, is that something that they can appeal as well?
Yes.
Okay.
Yeah,
okay.
yeah. You can appeal any case that has been tried, but it usually is on procedure. It has to do with what evidence they've allowed or not allowed. You can appeal if new evidence comes out, and have the old verdict thrown out. Hopefully, have the old verdict thrown out. Somebody was just released from prison. He was arrested for armed robbery, and he's been in prison for 11 years now. It turns out that a look-alike was the individual he had. Eyewitness testimony, and it proved.
I saw this article that says something like this guy, he died or something in prison, and then he came back to life, and then he went to court.
He said, I served my life sentence because he died.
How long was he dead? Or
Just a couple of minutes.
Yeah.
I mean, it
Oh,
happens.
okay, so.
Couldn't have moved very long, because otherwise you'd have brain damage.
Brain damage,
Yeah.
exactly. Yeah. You
And
got
they
about-
released him?
Yeah. No, they haven't.
Oh.
No. Good idea, though. I died once. I died a couple times, actually. Luckily, they brought me back fairly quickly, so that the amount of brain damage is fairly minimal. Or not at all, I guess. I was in a coma for about 2 weeks one time, but I'm okay now.
Well, are you really?
I don't know.
How do you know?
I don't know. Yeah, exactly. I seem normal to me.
Was someone able to prove that?
No, I don't want to take a test, that's for damn sure. The level of agreement between the jury and the judge was also high in civil trials, so in criminal trials, the jury tended to be a little bit more lenient than the judge was. This is logical because, well, I mean, one has to do with the law and the other has to do with their feelings. So juries, I guess it's logical that a jury would be more lenient because they make decisions on feelings rather than on the law. What accounts for discrepancies between the judge and the jury? Calvin and Zeisel attempted to answer these questions by delving more deeply into the judge's reactions to the cases and comparing them to the jury's verdicts. A few discrepancies apparently resulted from the facts that one party knew what the other did not. Judges have more information than the jury does. Sometimes the judges will decide that the jury can't hear select pieces of information, select pieces of evidence. They throw out confessions or whatever. So the jury only has what the judge wants them to have. They only have that information. But judges, of course, they have all the information. It's kind of like being the President of the United States. The President of the United States gets to hear all of these briefings, so they've got all kinds of information coming in. So theoretically, anytime a president makes a controversial decision about something, a lot of times they have more information than we do. I mean, we don't have any secret information. They have the NSA. Other presidents use the NSA, the FBI, the CIA. They get information from all three of these sources, so they have information that is not public. The judge is the same way. The judge has information that is not privy. The jury isn't privy to that information. About half the disagreements involve jury sentiments, situations in which the judge's view, the jury verdict was determined by factors beyond the evidence of the law. This has to do with emotion. You're dealing with 12 individuals. You just snatch them off the street. You put them in a room, and they have to make a decision. So you're going to get more emotional decisions than you would from a judge. Not only that, but of course they're seeing this case as a one and only case. Judges see cases one after the other, and they get a little bit tainted. They get a little bit callous. I talk about this when I talk about working in the emergency room. You work in the emergency room, and you stop seeing people as individuals. You don't have an emotional attachment to any of your patients. You identify them by their injury. The gunshot wound in 3, the broken arm in 4. You start talking about them as you identify them by their problem, which is not a good thing, but at the same time, it's the only way you can handle so many different cases. If you got emotionally involved in every case, then of course you would break down after working a couple hours in the emergency room. Jurors' sentiments play a role in decision-making when the jurors believe that the crime is too trivial for the expected punishment. This is one of the problems we've had with drug trials, especially marijuana trials. This is what was happening. This is one of the reasons that they legalized recreational marijuana in select states. They were throwing people in jail for usage for 6 months, 18 months, whatever. And they felt that the punishment didn't really fit the crime. Jurors believe that the defendant has already been sufficiently sanctioned. This happens frequently, especially with poorer people who can't afford to bail themselves out of jail. So they spend an extended length of time in jail. A lot of times they feel that that time spent in jail was enough. Jurors believe that law is unfair. And of course, that was another problem that we had with the drug laws. It's one of the reasons that they were prosecuting so many cases federally rather than statewide. Because in Colorado, of course, if somebody had if it was a drug case, a lot of times they just threw it out. And the jury threw it out because the jury didn't think that that was a serious crime. Then they legalized marijuana, of course. It was a really serious problem because they were releasing pushers. They were releasing suppliers, and of course that's not something that you want to do. If you want to stop drugs in the United States, you need to take away the suppliers. You need to throw those guys in jail. So the cartels were transporting a lot of drugs into Colorado, into Chicago, because the juries were more lenient. So they could make just tons and tons of money in Chicago, and they didn't have to worry about losing their supplies or whatever. A lot of times they were confiscated, the supplies were confiscated, but the suppliers were not prosecuted. Jurors see a crime as minor or victimless, and of course this is the case with prostitution. Prostitution is against the law. Who does it hurt? It hurts families, it hurts the individual that's the prostitute, potentially it hurts the guy, but it's a victimless crime. I mean, it's one of those deals where you can't figure out what's going on. They're having the same problems with marijuana in states like Colorado. Colorado, and especially California. In California, of course, it's legalized in California, so they're growing all of this product. They're growing a lot of marijuana, but they don't have a market for it. So what they have to do is they have to transport it someplace. Well, they can't transport it anyplace because all the states around them, it's illegal, so they can't send it anywhere. Even though it's legal in Washington State, Oregon, it's against the law. So they can't transport marijuana from California to Washington because they have to go through Oregon to get there. Okay. It's against federal law to transport marijuana, so they can't put it on a ship and sail it around to Washington State. So all of the marijuana, and of course the people in the growers in Washington certainly don't want to be flooded with California weed. So they got a problem. So now we've got a real problem because now they don't have a market. And so what are they going to do? They're going to transport it illegally is what they're going to do. And that's one of the things that's happening here. And in New Mexico, they're confiscating a lot of trucks, semis, full of marijuana coming in from California. It's against the law to transport marijuana because it's illegal. As far as the federal laws are concerned, it's illegal to manufacture it. So you can't transport it. So that means that when they drive through Arizona with weed, then you can seize it. The state of Arizona can, and New Mexico has really. New Mexico's only got one interstate, so and that's where all the marijuana is being transported across 40. Yeah.
So what happens to a person that was caught using marijuana at a certain point in time in their life, and then they apply for a job and they do background checks, and that state happens to have legalized marijuana? How does that impact the history or the background of that individual? Does it have any
Well, it's up to
impact?
the individual that's applying, or the individual that's hiring them. They can either, now that it's legal, they can either reject that felony, or they can accept it and use it as an excuse not to hire the person. It's up to them. As much fun as all this is. So a critique of Calvin and Zeisel. The judges were permitted to choose which trial or trials that they were talking about, that they were dealing with. There were 3,500 judges and only 500 of them actually responded. That's 1/7 of the individuals. Juries have changed in many ways since this study was conducted. There's increased diversity. Remember, this was in 1966. The civil rights laws were passed in 1963 and 1965, specifically 1965. So this was just a year after the civil rights laws were passed. It takes a while for laws to take effect. And in this case, of course, if we're talking about the South, then it was illegal for it wasn't illegal. They were blocking African Americans from voting. Now, normally you get your jury from your voter rolls, and since African Americans couldn't vote in the South, in most states and most counties in the South, then the number of jurors that you had that were African American was minimal to non-existent. So there was very little diversity. This wasn't so much the case in the North, but it was certainly the case in the South. The Southwest had problems. The West had problems with individuals who were of Hispanic descent. Now that probably wasn't especially true in New Mexico, where they considered they don't refer to people who are Mexican American as Mexican American. They refer to them as Spanish American. As interesting as all that is, because some of the oldest families in the United States are are of Spanish descent. And that's especially true in New Mexico, but not especially not acceptable in Texas, for example. So there were Hispanic individuals that weren't allowed to be parts of juries because there were a lot of transient individuals who were of Mexican, not only Mexican descent, but were actually Mexican citizens that were living in the had lived in the United States for an extended length of time. Well, while I was growing up, we didn't grow tomatoes, but our neighbors grew tomatoes. And of course, at that time, it was fairly labor intensive, and the individuals that came in to pick the tomatoes were migrant workers, farm laborers. Fairly common. They would live in Texas, and during the harvest season, they would travel throughout the United States harvesting all the crops. And this was true in Indiana as well. We grew green peppers and tomatoes. And so all of a sudden we'd have this influx of individuals. They could speak English, but they were migrant workers, and their parents were out in the fields harvesting the tomatoes, and the kids, because of the laws in Indiana, their kids had to go to school. So they would enter school in Indiana, and they would go to our school. Trini Lopez, he was a singer back in the 60s, was born in Indiana. He was a farm laborer, from a farm laborer family, and he was born in Indiana, as weird as that sounds. Anyway, so there's a lot of strange things going on back in the 60s, and that's the time they were talking about. Very little diversity. Almost everybody on a jury was white. Not only that, they were white males. And of course, we can't really check any of their results. The judges, it was whatever the judges said it was. Updated criminal case comparisons in 2005, Eisenberg and his colleagues collected data from jurors, judges, and attorneys in more than 350 trials. The rate of jury-judge agreement was 70%, which is really close to Zeisel's, what's the first guy's name? Calvin and Zeisel's 75%. And when there was disagreement in the juries were more lenient, and of course that agreed with Calvin and Zeisel as well. Circumstances in which jurors were more likely than judges to return not guilty verdicts. Jurors were more impressed than judges by the presence of a third-party defense witness. And of course, this is what we're seeing right now. If you're following the impeachment inquiry at all, we're getting lots and lots of witnesses, and we'll see if anybody's listening. If they're not listening, it doesn't make any difference. Nothing's going to happen. Jurors were impressed by the absence of a prior criminal record, and more impressed than judges were. Claremont and Eisenberg in 1992 examined plaintiff win rates in federal cases tried out before either juries or judges from 1979 to 1989. Differences emerged in products, liability, and medical malpractice cases only. Plaintiffs had more success with judges, 48% win rate, than juries, 28% win rate. So the juries were a little less flexible than the judges were. Researchers attributed the differences in civil cases to selection effects. The selection of cases tried by juries differed from those tried by judges. And of course they have a choice. They can choose to either have their case tried by a judge or a jury. Defense lawyers tended to settle cases in which the plaintiff had a strong case, typically leaving juries to decide relatively weaker cases for the plaintiff. Thus, they appear to make different decisions than judges do. So they were getting different cases. You really can't compare apples and oranges, and this was what the situation was. Usually, if the plaintiff had a good case, it was settled out of court. Now, if you have been listening to Donald Trump, you know that he's never lost a case, at least that's what he says. And to him, not losing a case means that he won, which is not the way it works. Anyway, a lot of times people have sued him, and he's taken them to court, and of course he's taken this thing out as long as he possibly could, and then he settled out of court, and according to him, that's a win. It's not a win. Well, anyway, it all depends on how you look at things. So we really can't compare the cases the judges see and the cases that go to a jury trial because they are different. They are different types of cases. Judges usually see a case where the plaintiff it's a slam dunk for the plaintiff, and jury cases are more balanced as to who is right and who is wrong. So you're not going to see the same types of cases. Another question is whether jury awards for punitive damages are different from awards assessed by judges, and whether the two groups differ on the reasons of those awards. Eisenberg et al. In 2002 found that judges and juries did not differ substantially. They awarded punitive damages of about the same size, although the range of the jury award was somewhat greater than that of the judicial award. So the jury tried to give away more money than the judge did. There's a reason for that. Juries, of course, get to see one case, and then they probably won't be on the jury for another 15 or 20 years. So they really don't they don't really understand how much of this money is actually going to be awarded. So a lot of times juries will come up with exorbitant amounts of money that the plaintiff should be awarded. Judges are a little bit more logical as to how much money they can actually get. The more money that they award, the more likely that the defendant will appeal, and they'll drag the thing out forever. This is what happened in the case that I was part of, where we were suing Bell Telephone. We won, but we never got any money. It's kind of still in the courts. Well, not actually, because what happened was the Bell Telephone dissolved. It's no longer Bell Telephone, it's AT&T. I know. So the company that we sued doesn't exist anymore, and when they dissolved, they took away all their assets. And since they took away all their assets, they had no money, and they weren't a company anymore. So we destroyed them. Well, not really. They broke up into all these little different companies. But I mean, they awarded us this exorbitant amount of money. It looked like I was going to get a couple $1,000s back. But as it turned out, they never had to pay any of the money. Who were they paying it to? They were paying it to military personnel. About half of us had been killed in Vietnam, so that was, they would have awarded that money to the family of the individual. And that was part of the excuse for not paying anything, was the fact that most of the people that they had injured were no longer alive, so they weren't going to pay us any money, and they didn't pay us anything. Yeah, and of course the problem is that juries do not set reasonable punitive damages. They're just not. It just doesn't make sense. I mean, how much of a punishment does this have to be? Well, a lot of times a company will make $1 billion off of something. They ripped off everybody. They will sue them, and they will have to pay a penalty of $2 million. So and this is what happened with Ford. If you remember, Ford had the Pinto, and the Pinto, if you ran into the back end of it, it exploded. Burst into flames, and hundreds of people were killed. Over 100 people were killed. Don't let me exaggerate. Over 100 people were killed, and they made more money off of not repairing that car than they did paying out to all the 100 people that died. It's just the way it worked. So they actually made a profit off of the Pinto, despite the fact that it was a car that blew up. This kind of stuff happens all the time, unfortunately. Unfortunately, we can't award damages that actually punish the company because the company makes too much money. And they would rather make the money than pay the damages. Or they would rather pay the damages and make the profit off of the part that is that malfunctions. Jury selection begins as officials assemble a panel. This is known as a venire. And a venire is prospective jurors, so they'll have maybe 500, that's too many. They'll have 100 people come in for a jury of 12. Jury selection must neither systematically eliminate nor underrepresent any subgroups of the population. So there have to be, if there are Hispanics in the population, there has to be a certain percentage of Hispanics. If there are natives in the population, there have to be a certain number of natives that they call in. To encourage representativeness, U.S. Supreme Court cases since 1880 have forbidden systematic or intentional exclusion of religious, racial, and other cognizable groups from jury panels. For a time, they didn't want anybody who was gay. They didn't want anybody who was Catholic. They didn't want anybody who was Jewish. They didn't want anybody who was black. They didn't want anybody who was Asian. For a long time in the West, and I'm sure this didn't happen in Arizona, but it certainly happened in Montana. If you were Asian, then you didn't, you weren't considered a human. So they would do all kinds of horrible things. They did the same things to natives, but they tortured the Asians to death, as weird as that may seem, because they saw them as tainted individuals. And the reason they saw them as tainted is because they smoked dope. They smoked opium. And anywhere you had a group of Asians, you would have opium, which grows relatively freely along the West Coast. So these individuals would, they'd have opium dens, as weird as that may seem. Anyway, so they started writing, or the Supreme Court started looking at this, and they said, you know, we've got a lot of Catholics and Jewish people in New York City. You can't exclude them from your jury just because of their religion. For a long time in the United States, Catholics were denigrated. Between 1880 and 1920, 60% of all the immigrants who have come to the United States came to the United States between 1880 and 1920. Most of those individuals were Southern European and Eastern European. And because of that, they were Catholic. So we had this huge influx of Catholics coming into the United States. So that's one of the reasons why, if you look at what the Ku Klux Klan was saying, when they had the resurgence in the 1880s and 1890s, they were against Catholics. They didn't like Catholics, so they would burn churches and whatnot. They would kill priests and whatnot. As stupid as that sounds, there's a lot of stupidity that's been in the United States, unfortunately. Historically, most veneers were made up of middle-aged, well-educated white men. They were overrepresented in these veneers. So even if you watch an old movie, like from the 1930s or 1940s, or even the 1950s, you'll see a jury of white males, all wearing hats and suits. You very rarely see any minorities in the group. You very rarely see anybody that's relatively poor. They're usually fairly well-educated white guys. The U.S. Supreme Court and Congress established the requirement that the pool from which the jury is selected must be a representative cross-section of the community. So if you have, so let's say Texas. What's the racial breakdown in Texas? Does anybody have a clue? What about here? What about in Arizona? What's the racial breakdown in Arizona? What's the dominant racial group in Arizona?
think it's Hispanic.
Hispanic? I think it's Hispanic too. I'm not exactly sure. You can look it up on your computer. Quick facts. Census quick facts. And then you can find the racial breakdown. I know it's exciting. Racial quick facts for Arizona. It'll tell you exactly.
Speaking of Asians, there's another shooting that happened in California, high school.
Another shooting in
Mhm.
California? Jeez, they just had one last week. And then they were trying to ban guns from schools. Most states have banned guns from anywhere being close to a school, except Texas, of course. So what's the dominant racial group in Arizona? Does anybody find it? Quick facts? Census quick facts. White? What's the percentage?
82.8%.
82? Really? In Arizona? Huh. Who would have thought?
Second is blacks, Americans, American Indian.
Look up Texas.
I have demographics of Arizona. I don't know how accurate this one is. It says blacks or African Americans make up 3.4% of the population. 3.3% are non-Hispanic blacks. American
Okay.
Indians make up 4.5%. Asian Americans 2.3%. Pacific Islanders make up 0.1%.
How about whites?
Whites, they've eliminated you guys. Just kidding. I'm just kidding.
So those will have to look up Texas. I think you'll be shocked. Whitest place in the United States. That's not true. Whitest state in the United States is New Hampshire.
So it would be Arizona census, right?
No, quick facts for Texas. Census quick facts. Texas.
Texas is whites, 78%.
78? And then the rest of everybody is Hispanic almost. Okay. What's the percentage of black people in the United States? Does anybody know? It's around 12%.
For Hispanics?
No, African Americans.
Isn't it
Hispanics are close to 15%.
Isn't it something like 38%?
Yeah.
Something like that, I know it's.
So what was the percentage of blacks in Arizona? 4?
Percentage of blacks is 13.4.
In the United, 13.4?
Yeah.
Okay.
What's it
But in
done?
Arizona, it's 4.4?
Well,
Well, we're getting different demographics.
It depends on who's doing the census.
Who's doing the
Who's
census?
doing the data. Because I'm getting different numbers.
Well, you're probably looking at different census data. You're also getting,
Unless you go to US Census.
yeah, you can go to the US Census, but you're gonna get 2010.
US Census.
Anyway, so you have fewer African Americans in this state than is the average. If it's 13.4%, you've only got 4.5%. You don't have enough African Americans, but you need more African Americans in this state.
So that's going to change because you got the 2020 census coming up, right?
That's 2020 census, right? We estimate we assume that everybody increases at the same rate.
Every year?
So what they do is they estimate
Oh, okay.
over the 10 years between 2010 and 2020.
What was that formula in statistics? There's a formula that you use to estimate populations. What was that? What was it called?
I don't know. I don't teach statistics. I haven't taught statistics in 12 years. Anyway, okay, so what the problem is, we need a representative veneer. So we need, in Arizona, 4.4% of the of the people would have to be African American. So you'd want 4 or 5. If you had 100, if you brought in 100 people, 4 or 5 of them needed to be African American. It was about the same percentage for natives, wasn't it? You guys don't even make up 5% of the population. Right? In Arizona.
I don't think that's right, but yeah.
Live on a reservation where it's like 99%.
Wait, where are we looking
It says 5.3.
5.3?
Yeah.
Okay, so 5 people would have to be African American, and 5 people, maybe 6, would have to be native in Arizona. Yeah. So if you've got 100 people, if you're bringing in, if your veneer is 100 people,
You need 5 natives?
you need at least 5 natives and you need at least 5 African Americans. And the rest of the people would be, you'd have one or 2 Asians, you would have 13 or 14 Hispanics, and the rest of the people would have to be white.
So when you're selecting jurors like that, do they also take into consideration their religion background?
They can, they could, if that became an issue. Probably it wouldn't become an issue, because you'd have to ask people what their religion was. And I don't know, and it's probably on the historical form that you fill out when you become a juror. When they call you in, you tell them what your race is, you tell them what your religion is, you tell them what your age is. There's another problem that they have, that the veneers tend to be too old, because, I mean, the only people that come in are the retired people. The rest of the individuals don't leave work so that they can go to jury duty. Okay, so why do we do this? There are 2 reasons. This would result in juries that are more heterogeneous. Are there advantages to that? Minority members might discourage majority members from expressing prejudice, and this is a good thing. Heterogeneous juries would be better fact finders. They could examine things from different points of view. And that's the idea behind this. That's one of the ideas anyway. The second reason is jury representativeness, which would give the appearance of legitimacy. The more minorities you have on the panel, the more it looks like that you have a fair jury. Juries should be selected by the standards of the community. In other words, if we were in Gallup, New Mexico, which has a relatively large native population, you would expect to see more natives on the jury. When certain components of the community are systematically excluded from jury service, the community is likely to reject both the legal process and its outcomes as invalid. And this is one of the problems they had with the OJ decision and the Rodney King case. Those both went to juries, and most of the people on the juries were white. And because of that, the African American community rejected the decisions. They didn't like the decisions. Well, in the OJ decision they did, but then white people were pissed off. But they didn't riot in the streets like they did with Rodney King. How do courts go about forming the veneer in order to make the jury representative? For many years, voter registration lists were used as the primary source for jury pool selection, but such lists underrepresent segments of the community. There's something else about jury lists. They don't give your race, they don't give your religion. They give your political party, and that's about it. Recently, other sources such as lists of licensed drivers have supplemented voter lists as a source of prospective jurors. There are individuals who will not vote because they don't want to go to jury duty. As stupid as that sounds, there are people who don't. There are a lot of people that don't vote. In the last election, it was like 71% of the people didn't vote. Only 29% voted. So we will see what happens in the future. People don't have to vote. That's part of your constitutional right. You don't have to go to church, and you don't have to vote if you don't want to. It says that in the Constitution. You have freedom of religion.
But you have to pay taxes.
Well, everybody, yeah, you have to pay taxes on, well, some people have to pay taxes. Strangely, wealthy people don't pay taxes, as weird as that sounds. So let's elect a president that's going to tax the wealthy. Let's do that.
Do you think there's like any, like if somebody were to say, I guess, kind of like how Trump was saying, he could get a gun and just like shoot people and nobody would care or whatever. Do you think there should be like repercussions for that?
For saying that?
Yeah.
Well, I think it's true. We know that wealthy people are more likely to get off than people that are poor. It's kind of true because nobody cares that he tried to bribe the Ukrainian government. There's a lot of people in the United States that don't care. They think that he can do no wrong because he's wealthy. So I think, yeah, that's true. He could take a gun and shoot somebody.
I just saw this video on Veterans Day about this old guy. He's a World War II veteran. And he was at I guess it was a rally, and then there was a protest against Trump. And they had this barrier between them. And he started yelling at the group across, telling them like, oh, I sacrificed all this for you guys to do that. He was saying stuff like that, and then they were just like peacefully protesting. And then he started getting heated, and he was like, give me a fucking gun, I'll shoot all these guys.
So he was going to shoot all those people that he had fought and bled for so that they could do that. Then he was going to kill them all. Okay, well, that's kind of an interesting idea. It's kind of like me shooting my son because I have the right to shoot him. I'm the one that made him, so I'm the one that can take him out, right? Is that the way it works? Logic. Sometimes it's weird. From those persons who are eligible for jury service, members of the VENIRE are randomly selected and summoned to appear at the courthouse for jury service. So what they'll do is they'll get a pool of names, and this month we have 500 names. So whenever they call a jury, they'll pick 100 of those names and they'll call them in for jury's duty. Now, strangely enough, half the people will not show up. They will ignore this summons. They won't answer it at all. This is kind of what's happening with the Congress. Congress is subpoenaing select individuals, and they just refuse to come in. Now, you can do that, but if they want to, if Congress wanted to, they could throw these people in jail. It hasn't happened since the 1880s. So probably they're not going to go and hunt down John Bolton and throw him in prison in D.C. It probably isn't going to happen. Another one is Mick Mulvaney, who is the acting, what is he? He's in charge of Trump's, of the White House. I can't think of what the name of it is. Anyway, Mick Mulvaney is another one that ignored the subpoena. So theoretically, they can arrest them. Theoretically, they could arrest all the people that don't show up for jury duty. They could go and find them and throw them in jail. They could do that, but they don't. They just ignore it. They could if they wanted to, but of course nobody wants to. In an effort to determine if prospective jurors are prejudiced, the judge and or attorneys can question the prospective jurors in a procedure called voir dire. Who asks the questions, what questions are asked, and how they are phrased, how long the questioning goes on, and whether the questions are posed to the individual jurors or to a group are all matters left to the judge's discretion. And all the judges are different. So one judge will ask everybody, is there anybody out there who has a relative in the oil industry? And they'll raise their hand. Is there anybody out there who doesn't like African Americans? And then they'll raise their hands. They can do it that way, or they can question the people individually. It takes a lot less time if they do it in the group, as a group. A limited form of voir dire involves yes or no questions asked by the judge and answered by the group, not individuals. Yes or no questions offer little insight into jurors' beliefs and attitudes, of course. This form of questioning requires jurors to identify and report their biases. Nobody likes to report the fact that they don't like white people or whatever. They don't like to admit that, so a lot of times you don't get honest answers. Many may be unaware of their biases or hesitant to publicly state them, and of course this is the biggest problem. The social desirability effect may be a factor here. They want to be socially desirable. They don't want to be rejected by society just because of their prejudices, like the World War II guy that wanted to shoot all the people who disagreed with him. I was just reading an article about a guy that voted for Trump, and he lost all of his liberal friends. They won't communicate with him anymore. So we've got kind of the same thing. I guess they didn't shoot him anyway, but they just won't talk to him anymore because he is a Trump supporter. Extended voir dire, in which the judge and attorneys ask open-ended questions and question jurors individually, has advantages in uncovering biases. And if you watch any of the television shows, there's a new one on Her Honor or something about Rising. I don't remember. Anyway, it's about a black judge, female black judge. And of course, she runs into all kinds of interesting situations because she's female and because she's a minority. You can watch Bull. Bull's kind of interesting because he is looking for, he's trying to load the jury with people that will agree with whatever his client wants, which is kind of curious. It's an actual, that's what Phil McGraw used to be, Dr. Phil. The infamous Dr. Phil. Dr. Phil's from Oklahoma, I think. Anyway, he's a psychologist, and he became a jury consultant back before there were jury consultants. So he started a trend. He wasn't the first one. He actually started working with somebody else. But he became the most famous, and of course, Oprah was being sued for something, and she hired Phil McGraw. And then, of course, after that, she used to call Phil McGraw into her program all the time. He was a psychologist, and he was kind of an interesting person. Rational emotive therapy is the type of therapy that he uses. I don't know if you've ever seen. He's got a new television show where he in 30 minutes he solves people's mental problems. Really kind of curious. He's a rational emotive therapist, however. It's kind of directed. He's a little bit more directed than most people. He's certainly not a visionary. Yes.
It reminds me of Jerry Springer.
He is a lot like Jerry Springer.
Because Jerry Springer now has a VOIR show.
Oh, is that right?
Yeah.
Jerry Springer used to be the mayor of Cincinnati, and Jerry Springer was thrown out of, he was impeached because he stole some money from the city of Cincinnati. How he became a television star, I have no idea, but Jerry Springer's kind of an interesting person. My son was an actor in Hollywood, and he tried out for the Jerry Springer show. Because none of those people are real, they're all actors. And my son was supposed to be an angry gay man because his significant other was messing around on him. That was what he was. So he was supposed to get in a fight. It was really kind of, he actually didn't get the part. But he had to act it out on stage. Really kind of weird. So they had him dressed in this, muscle shirt.
I just saw this, it just popped up. I was trying to look for it, but there was just a shooting. And another high school, 7 injured.
7 injured, nobody dead?
One critically.
Oh, jeez. In California.
I think so. It was what is that?
Says Asians or
Saugus,
Asians.
Saugus or something?
Oh, good. Anyway, okay, so what's going on? So the lawyers can ask open-ended questions. Individual questioning can result in disclosures that jurors might not otherwise offer because they are open-ended questions. But extended voir dire can take a long time, so most courts tend not to favor it. So what they actually will do is they will make group inquiries usually. Typically, voir dire procedures involve a compromise between the limited and extended versions. Both the attorneys and the judge pose questions to a group of prospective jurors, and then they ask brief follow-up questions by selected individuals. Challenges for cause and peremptory challenges. There are two mechanisms by which panelists can be excluded from serving on the jury. They can challenge for cause. In any trial, each side could claim that particular jurors should be excluded because they are biased. One of the questions they can ask is, do you have a relationship with this individual? Have you ever worked for Walmart? If Walmart's being sued, do you have any relatives that work for Walmart? If so, then they will exclude you for cause. This is known as challenge for cause. You can throw anybody out for cause if you want to, as interesting as this is. So if the defendant is African American, for a while they were allowing lawyers to throw out African American jurors for cause because they were African American, assuming that African Americans would be more sensitive to the African American defendant. So they would throw that out for cause. They don't do that anymore. They can't do that anymore. Race, religion, or other extenuating circumstances cannot be used to challenge for cause. So you can't throw somebody out just because of their race. You can't throw somebody out just because of their religion. You can't throw somebody out just because of their sexual orientation. Peremptory challenges. Each side may also exclude a designated number of prospective jurors without a reason stated. You can just exclude them. And this is, of course, what they're talking about on Bull. That normally they have these peremptory challenges. They tell them how many they're going to have before they start. So they try to exclude the jurors that are not going to come up with a favorable decision as far as they're concerned. The number of peremptory challenges for each side varies among jurisdictions, the type of case and the seriousness of the charge, and of course that has to do with how many they get to exclude. Peremptory challenges have multiple purposes. Peremptory challenges allow attorneys to challenge potential jurors who they believe will be unsympathetic to their client to their client for whatever reason. Peremptory challenges allow those in a lawsuit to play a role in selecting the people who decide the outcome. Thus, they may be more satisfied with that outcome, of course, because they have rejected the individuals that they thought might destroy their case or might not agree with their case. Peremptory challenges also allow the attorney to begin to indoctrinate prospective jurors and influence those who ultimately will make up the jury by selecting them. There's a lot of psychology involved in this. If you're selected, it's almost like you won something. You didn't, but it's almost like you won something. So you start thinking favorably toward that attorney. The Supreme Court has ruled that peremptory challenges may not be based solely on a juror's race or gender. As I said before, you can't just have all males, you can't have all females, you cannot have all white jurors just because they're white. Batson versus Kentucky in 1986, no exclusion based solely on race. The Supreme Court were dealing with this. Remember, civil rights was passed in 1965, and here it is 1986, and they were still rejecting people because of race. So the civil rights, the battle for civil rights in the United States has been going on forever, and it continues to go on. And the Supreme Court didn't recognize this until 1986. The fact that juries were being selected on racial bases. And of course, despite the fact that civil rights was passed in 1965, the playing field did not immediately become level in 1965 when the civil rights laws were passed. It took years of fighting in the courts in order to get more equal treatment for people. And of course, in the case of Batson versus Kentucky, it was 1986. This is over 20 years later. They're still fighting. They're still making these decisions about civil rights. When a defense attorney believes that the prosecution's peremptory challenge was motivated by racial factors, he or she initiates a so-called Batson challenge. And the judge then asks the prosecutor for an explanation. The prosecutor typically advances a race-neutral explanation for the challenge. The judge then determines whether the explanation is genuine. So he may not want African Americans on his panel. He may not want African Americans. So if he excludes an African American, he comes up with some excuse for excluding them that has nothing to do with race. And then the judge has to make a decision as to whether his explanation is logical or not. Now the reality may be the only reason they rejected him is because he's African American. That's the reason he rejected him. But he comes up with another excuse. So the judge will have to make a decision. And if the judge decides to exclude the juror, then the other side can challenge. And they can take it to another court. And because if they decide the case and the case goes against a select individual, that individual can appeal because of the Batson rule. I know. So this gets really, really strange. If there is actually racial prejudice taking place, then they can use that in the appeals. In which case they'll have to throw out the case and they'll have to retry the individual with a different jury.
Is that what they call a mistrial?
I'm sorry?
When does a mistrial happen? What happens to determine a case as a mistrial?
They'll hear the case. The case will go all the way through the courts, and then the side that loses will appeal the case, and then they will take it to the appeals court. And the appeals court, this is what the appeals court is looking for. They're looking for cases where the Batson rule has been broken, in which case it's automatically thrown out and have to retry the case. And this is one of the reasons why the courts are so tied up, because of cases like this. A good judge, of course, will make sure that the Batson rule hasn't been broken. He makes sure, he or she, whichever the case may be, makes sure that the case is there's no question as to whether the Batson rule is broken. Now this gets kind of interesting, because if you remember, once upon a time, Donald Trump was being sued for Trump University.
Is he being sued again for
I'm
the
sorry?
veterans thing?
I'm sorry?
Isn't he being sued again for the veterans thing?
No, he settled out of court.
Oh,
Yeah, it's all gone. All that's gone. But if you remember the case was he swore that the judge couldn't try his case fairly because the judge was Hispanic. And as it turned out, of course, the guy was born in Indiana. He claimed he hated him because he was an immigrant. Well, he wasn't an immigrant at all. He was born in Indiana. He just happened to have a Hispanic name. So here we have the president that's undercutting all of these laws that we've had for a while anyway, for 50 or 60 years. He's undercutting them by making a statement like that. How stupid can you be? I'm sorry. Evidently really stupid. He's doing a really good job.
Hasn't that been proven over and over again for this president?
Yeah. No, he's a stable genius. I've heard that before. He's a stable genius. It's obviously very bright. Anyway, so it can go to appeals if they prove that the Batson rule has been misapplied. In 1994, the Supreme Court extended the logic of Batson to preemptory challenges based on gender. This was JEB versus Alabama, ex-rel TB, 1994. This had to do with a case that where they flooded the jury with males instead of females. They didn't want any females on the case. It was a case of rape. There was a case of rape in Spain. I don't know if you heard about this one. The young lady was drunk and she passed out, and 5 men raped her. They were acquitted because she didn't fight. I know, this is in Spain. They were having riots in Spain because of this. I know, stupid stuff. Oh, she didn't fight. Well, she's unconscious. Of course she didn't fight. Would that happen in the United States? I don't know. But I mean, there are some really dumb people out there. So maybe there is a judge that would say, oh, you didn't struggle, so obviously you didn't think you were being raped.
That's crazy, because I was on YouTube last night and I seen this video of this guy that interviewed Asian or Japanese. He's asking the Japanese about like their perception of sexual harassment and what their take on it was.
Mhm.
So it's pretty crazy. Like they actually have a different perspective on it too, especially when it comes to power. Like if it was a man making kind of like making sexual references to a woman who's in that lower working position than the men, then they would kind of just let it happen.
It's not sexual harassment.
Yeah.
Well, see, the Japanese are kind of funny because the Japanese have a rape culture. The more powerful somebody is, the more they have a right to have sex with somebody. If you watch old samurai movies, the samurai always kills all the men and then he wanders off behind he rapes whoever he wants to rape. He takes them behind the screen, has his way with them. And this is part of their culture. So rape doesn't have the same definition in Japan as it does in the United States, as strange as that may seem. That's one of the reasons why you saw that on the video. There's a word for it, and I've been looking for that word. It's a Japanese word, I can't find it. But when I was in Japan, they had a whole section of the bookstore was not that large a section, but it had to do with this whole rape culture thing. So it was stories about men that raped women, and it was part of their literature. As strange as that may seem, I know it's weird. The Japanese are just different than we are. But at the same time, I mean, we already know this. I talked about this before. It's what is it? 25% of Japanese over 30 have never had sex. So, and in the United States, it's like 3% or 5% or something like that.
But the crazy thing about that is they also had like woman-only carriages, so they could try to like reduce the sexual harassment. Because it happens a lot on the train.
Well, yeah. Well, of course, it's happening on the trains. I mean,
Yeah.
if it's very, very crowded, and everybody's pushed right up against everybody else. So if you move at all, it's kind of like sexual harassment. It's really kind of bizarre. Why don't we stop right here since I got into the Japanese again?